Mr. Tabrugi, you're up.
May it please the court, Adam Tabrugi, Bradenton, Florida. On behalf of the appellant, Brett Wallace, request 5 minutes for a rebuttal.
Okay.
In this case, I was also the trial counsel. And as trial counsel, one of the issues that very much concerned me was the denial of the motion for severance of the 2 charges in the information. Under Florida Rule of Criminal Procedure 3.152, if the offenses have been improperly charged in a single information, the defendant shall have the right to severance. It's my position that these offenses were improperly joined. The offenses occurred on different dates. They were separated by a week, different locations, different victims.
I think the judge kind of like honed in on the fact that there was a flight involved that led to the second offense, and the flight was because it might be evidence of guilt as to the first offense. So they were kind of intertwined in the judge's world. How to separate that out? How would a jury not have found out about it anyway?
Your Honor, the evidentiary issue, to my mind, is much different than the procedural issue. Could there perhaps have been evidence of flight presented at the Berkeley trial?
Well, it kind of goes to a harmless error. I guess that's where I'm coming from.
So here's the problem that I saw. If it had simply been evidence of flight, it would have just been the testimony of the detective. Oh, we went to go get the defendant, and then he fled after we asked him where's the jewelry.
All right.
But since this case was now being tried, we not only had the testimony of the detective, but we had testimony as to injuries that he suffered. There were photographs that were introduced into evidence by the state showing these injuries, showing damage to a vehicle out in the parking lot. They were able to call an additional detective to corroborate his account of this struggle that occurred. And we had to defend against it.
Were those specific objections put on the record below at the time the evidence came in? Because you're tying that back to the denial of the motion to sever.
I am. Because once the charges are being tried together, then there's no doubt that this evidence is going to come in because it's perhaps relevant to the resisting arrest violence charge.
In answer to the question, those specific arguments were made as objections to the admissibility of the evidence?
I don't think that they could have been, Your Honor, once the motion for severance was denied.
Okay. Just making sure.
And that gets back to, as trial counsel in this case, it was extremely important to our strategy that this resisting charge not be tried at the same time, because it took the focus away from the very interesting burglary charge that we were attempting to defend against.
But wouldn't that be probative? And this is where that, even if you've had the severance, let's just assume that, evidence of his resistance, of your client's resistance, would still have been admitted at the Berkeley trial, because that was done in response to the officers asking him about the missing jewelry, telling him he's under arrest, and there's case law that basically says that flight was probative of somebody's identity. There was another case where a person was involved in a robbery, and they said that was probative, even if no other crimes are charged. So how do you balance that?
Your Honor, the flight potentially could have been admissible. Actually, the evidentiary question was never squarely addressed, because once the motion for severance is denied, I'm left without a leg to stand on to say, well, this wasn't really flight. But regardless, it's the fact that we had to then focus our whole defense as to the resisting arrest with violence charge. We had to call additional witnesses. We had to make arguments. And so that's the prejudice that we suffered. If it had just been an evidentiary issue, it would have been brief, and the jury would have been instructed. This was introduced solely for this purpose. As it was, the evidence was not brief. It was a feature of the trial because it was one of the charges that we were defending against. And we had to call witnesses. And again, as trial counsel, that was something that very much concerned me, particularly when the rule says that you are entitled to the severance as a matter of right. It's very rare that as trial counsel I get to make the decision and say, Your Honor, I want this severance and I'm entitled to it as a matter of right, and it was not granted. So that's my answer there. With respect to the burglary charge, I first note that we know very little about the actual crime, except that the quote-unquote victim, Miss Creasy, had checked into the hotel, had brought some items of personal jewelry with her, and all that we know is that she said, well, they were in a cardboard box with a rubber band around them. They were there on the 20th, and when I looked for them on the 21st, they were missing. Well, there's a long-standing rule that unexplained disappearance of property without warrant does not constitute a crime. And there's a good reason for that rule. How many times have I misplaced my wallet and been unable to find it? Is that necessarily evidence that the wallet was stolen? Of course it's not. I mean, for all we know, this cardboard box is still fell behind the dresser at the Holiday Inn.
But you cannot really look at that in a vacuum. You have to look at other evidence in this case. The fact of the key card entries, the key card log, and you can't just push that away. And what's interesting, that ultimately what was found at your client's home. So you can't really focus on one thing and then disregard the others. So help me out with that.
Yes, ma'am. So with respect to the key cards, these are things that needed interpretation. It's not self-apparent when you look at these documents what they are or what they mean. And when the person who testified before the jury gave the interpretation, he also had to admit that when he first spoke to law enforcement, he had come to an entirely different interpretation of these documents. So the key cards are, in my opinion, a questionable piece of evidence that is entirely dependent upon the manager, Mr. Party.
But that's fodder for the jury.
I understand. I understand, but I was responding to the question here of place this in context. And so the other item that you noted, Your Honor, is this pendant. Well, it really is an interesting issue. If the victim had lost 2 brand new $20 bills, and 2 brand new $20 bills were found in the defendant's possession a week later, we'd say, well, that doesn't really prove anything because $20 bills are not unique. In this case, the item is distinctive, but it's not unique. An example of a unique item might be a class ring that had a special engraving on it. Evidence was presented that this item continues to be commercially available on the home shopping network, over the internet. Is it a distinctive item? Yes. Is it a unique item? No, it's not. So I just think that when you take this all into account, we do get back to the proposition that all we have here is unexplained disappearance of property. And that also certainly would like to address the jury instruction with respect to this piece of property. I did object to the jury instruction at the trial court, and we got into a discussion as to whether or not the defendant was in exclusive possession of the pendant. Because in order for this jury instruction to be given, there must be proof that the defendant was in exclusive possession of recently stolen property. This was not an exclusive possession case. If you think of it almost like drugs, this would have been a constructive possession case with respect to the pendant. Other people lived in this apartment.
I guess I'm confused, but didn't your client testified that this was his, so in essence, he was in exclusive possession of it.
You'll note, Your Honor, that before he took the witness stand, I told the judge that the reason that we were now calling him to the witness stand is because the court had decided to give the jury instruction. Otherwise, we would have relied upon a lack of proof. And I felt like he had to take the witness stand in order to explain the origin of this piece of property. But I never conceded that the jury instruction should be given, if that makes sense. And of course, the only reason that this pendant was even located was due to a search warrant that was based upon an affidavit that was wholly insufficient to lead anyone to believe that property would be found at this particular location. In the brief, I go through the well-established law that search warrants are directed at property, not people. And if we read this affidavit, we have no inkling as to why law enforcement believes that they may find evidence at this location. It's not even alleged in this affidavit that this is, in fact, the defendant's residence. It's simply alleged, well, we believe that the defendant committed this particular offense, and we want to search this particular location.
But
Well, where was
didn't
the
the
bo-
affidavit go into detail and said the information in the affidavit kind of supported a finding that there was a fair probability that your client had stolen the jewelry. It said that it was stolen out of the victim's hotel room. Key card entries to the room coupled with the key card log suggested that your client had entered the room during that short period of time when the jewelry went missing. And then those allegations support a finding that the stolen items could be found at his residence because the stolen items were small, and that's just the type that someone would probably hide in their home. And the burglary only occurred a week prior, so there's that belief that the perpetrator would still have those items. You don't think none of that's sufficient?
None of that is in the affidavit, Your Honor. The only thing that's in the affidavit is the allegation that he committed the crime. But there is nothing in there about why it's believed that evidence would be found at this location. It's not even alleged this location is, in fact, the defendant's residence. So there's this complete lack of nexus evidence that's in the affidavit. So I'll reserve the remainder of my time. Thank you.
Please the court, Mr. Buckington, on behalf of the state in this case. I need to first address counsel's points regarding the affidavit. So the affidavit specifically describes the location, gives the address. Counsel is correct. It doesn't say, and our defendant lives at that address. But the affidavit does recite the date that he was approached by the detectives, that myself and Detective Camacho went to the defendant's residence and located him outside his apartment. So there's a very clear implication that he lives at this apartment, which we don't know where they are.
And the box was found in the bedroom or the TV room?
It's my understanding from the record, Your Honor, that it is a TV room being used as a bedroom by the visiting new resident in the home, the appellant in this case. And there was no claim regarding, as far as counsel's claim regarding being forced, essentially, to put the defendant on to testify, to explain the possession of cross, the argument regarding constructive possession and the fact that this cross is available elsewhere could have been made without the defendant's testimony. So that claim, we believe, is not a matter of a Hudson's choice in this case. I don't want to sit down yet because it's so nice to be here. So
You want us to pepper you with questions?
Yes, some questions, please, Your Honor. Personally, what was interesting I found in this case was I didn't know that when you go to a hotel that you can find this information, that you can run this kind of a query onto a door log and find out the various entries that were made into the room. So that in itself is intriguing.
Let's talk about the severance, because that was really Mr. to Bruges' main argument. Why don't you address that portion of it? Could the state have tried this case separated?
The burglary, the flight was definitely going to come into the burglary charge. Now, resisting arrest, if that was tried separately, would the burglary have to come in? No. So the one in theory, in the vacuum, the resisting arrest could have been tried. He would have been arrested. You wouldn't have had to go into the details of the burglary. That one could have occurred without the burglary information. But the burglary trial could not occur without the information regarding the
And the cases where it was a reversible error, there's no nexus or connection at all between crime A and crime B. Here, there is this little segue about the flight relating to the first crime.
Most definitely.
And the standard of review is abuse of discretion. He said he argued he was entitled as of right to a severance. And I'm asking you, is it the standard of review abuse of discretion? If that's the case, then the judge has to apply some sort of analysis or discretion in granting or denying the motion to sever. It's not as of right. And that's my question. Is it as of right, or is it still up to the judge to exercise discretion?
The judge has to apply discretion in determining whether or not these are separate crimes that should be severed or not joined.
So it's not automatic. If the defense files a motion to sever, they don't automatically get a severance.
No, because you'd always have to look at, the facts of the crime
Okay.
to see what.
That was a softball. That was a softball. You gave me that deer in the headlight look, and I thought I did something wrong.
Based on the arguments made in the brief, the facts regarding the unexplained disappearance, we did talk about that briefly. Just to state the lines, and ask you to confirm the judgment since this case.
All right, thank you. All right, Mr. TeBruge, you've got your 5 minutes left. Answer that last question, because I think I might have confused her. Are you arguing you're entitled to severance as a matter of procedural right?
Yes, sir, I am, and I think that is absolutely clear in Florida law. In fact, this rule was amended to make that clear after there were appellate cases that said, well, the judge has some discretion.
And the reason why I asked, I could swear I read somewhere in your brief that you argued the standard of review was abuse of discretion.
That's what the case law says, and I know that doesn't quite fit with what I'm saying. I mean, theoretically...
Well, I mean, the rule can say A, B, or C, but if the case law says A, B, or C means D, that's what it means. So, I mean, I think you argued the proper standard of review, but now I'm hearing we don't need to get to the facts of the case because it's a matter of right.
It says right in the rule, obviously, that the defendant shall have the right if the crimes are improperly joined. So that's the test.
So it's the if. It's what follows after if that backs in the discretion of the court.
Yes, sir.
Okay.
And these crimes, in my opinion, were not properly joined. They are not connected in any type of episodic sense. They are separated by a week's time. And, Your Honor, with respect to the evidence, would the evidence have come in any event? There's some, we know in the sexual battery context, for instance, Williams rule evidence may be admissible, and that would be one thing. But it would be an entirely different thing if we're now going to say, oh, all of these victims you're on trial for as well. It's a different struggle that we're facing if we're simply dealing with it as, right, this was one piece of evidence in the trial, versus a whole crime that we're having to defend against.
And I understand, and just for clarification, you have every right under the rule to bring a motion before the court. So you have a basis to ask the court to sever. And that's what the rule is for, that you have an absolute right to do that. But then the analysis goes to the trial court. And the trial court then gets to review all the evidence and in his or her discretion, make a determination whether or not to grant your motion. And so for our purposes of review, we get to review this based on, did the trial court abuse his or her discretion when he or she denied your request? And so, for clarification, our review is abuse of discretion, correct?
Yes, ma'am, it is.
All right, all right.
And here's why the trial court did abuse his discretion. If you look at the cases, even those cited by Appellee, we have situations where, well, the crimes were committed within 12 hours of one another, so therefore they're episodically connected. Or all the crimes occurred at the same location. The defendant sold drugs from this residence, and 5 days later we found drugs at the residence. And that's the connection. You will not, and I do not believe you will find a case in Florida law of crimes that happened on different days, different locations, different victims, where you can say, oh, they were properly joined together in the same information. And so if they were not properly joined
Can I
together,
ask you a question?
Yes, sir.
If he had been charged with fleeing and eluding, would that have been a charge connected to the first charge?
only if we could say he committed the burglary and then he fled to elude right then and there. A fleeing to elude that occurred a week later, no sir, that could
But he
not
wouldn't
be.
charge with it. So you're saying either way it wouldn't have made a difference? He wasn't charged with fleeing and eluding, just resisting without violence?
Resisting with violence.
And he got convicted of the lesser? Okay,
Yes, sir.
okay.
And since the state didn't address the circumstantial evidence argument, I guess I can't reply right now, but I do ask the court to review that as well. Thank you very much.
Thank you.
All right,
Thank
well,
you,
thank
Bob.
the lawyers for coming.
Thank you.
We're going to be in recess.